Introduction. Chapter 7 Bankruptcy provides individuals and businesses with a fresh start by discharging most of their debts. It is one of the most common forms of bankruptcy in the United States. People may choose to file for Chapter 7 bankruptcy for several reasons when they find themselves overwhelmed by debt and unable to repay their obligations. Some common reasons for filing Chapter 7 bankruptcy include unmanageable debt. The debtor may have accumulated a significant amount of unsecured debt, such as credit card debt, medical bills, personal loans, or utility bills, and cannot keep up with the payments. Job loss or reduced income. A sudden job loss, reduction in income, or unexpected financial hardship can lead to difficulties in meeting debt obligations. Foreclosure or repossession. If a person is at risk of losing their home through foreclosure or their vehicle through repossession due to mortgage or auto loan arrears, Chapter 7 bankruptcy could provide relief and a chance to start anew. Harassment from creditors. Persistent and aggressive collection efforts from creditors, such as constant phone calls, letters, or threats, can be emotionally distressing, and filing for bankruptcy can trigger an automatic stay that stops these actions. Business debt. For small business owners facing insurmountable business debts, Chapter 7 bankruptcy can provide a way to close the business and discharge the related obligations. Medical expenses. Medical emergencies and high healthcare costs can lead to significant debt, especially if the individual does not have adequate health insurance coverage. Legal judgment. A large legal judgment against the debtor, resulting from a lawsuit, can create substantial debt that may be difficult to repay. No realistic repayment plan. If the debtor has explored other debt relief options, such as debt consolidation or a repayment plan, and found them to be unworkable or insufficient, Chapter 7 bankruptcy might be a viable solution. It is important to note that filing for Chapter 7 bankruptcy is a significant decision and should not be taken lightly. While it can provide relief from debt and a fresh financial start, it also has long-term consequences on credit and financial standing. Additionally, not all debts are dischargeable, such as child support, certain tax debts, and student loans in most cases.
Lesson 1A, Purpose of the Chapter 7 Bankruptcy. The primary purpose of Chapter 7 bankruptcy is to offer individuals and businesses facing overwhelming debt a fresh start by discharging most of their unsecured debts. It serves as a debt relief option for those who are unable to repay their debts and are in need of a financial reset. The key objectives and purposes of Chapter 7 bankruptcy include debt discharge. The main goal of Chapter 7 bankruptcy is to discharge or eliminate most unsecured debts, such as credit card debt, medical bills, personal loans, and certain other types of obligations. Once debts are discharged, the debtor is no longer legally obligated to repay them. Automatic stay. When a debtor files for Chapter 7 bankruptcy, an automatic stay is triggered. This injunction stops creditors from pursuing collection activities, such as phone calls, wage garnishments, lawsuits, foreclosures, or repossessions. The automatic stay provides the debtor with immediate relief from creditor harassment and gives them the opportunity to address their financial situation. Liquidation of assets. In Chapter 7 bankruptcy, the bankruptcy trustee is responsible for liquidating non-exempt assets to repay a portion of the debt owed to creditors. However, many assets are protected by state-specific exemptions, meaning debtors often do not lose all their possessions. Fair distribution to creditors. The proceeds from the liquidation of non-exempt assets are distributed fairly among the creditors, ensuring that each receives a proportional share of the available funds. Financial fresh start. Chapter 7 bankruptcy provides individuals and businesses with a chance to start anew financially. By discharging debts, debtors can alleviate the burden of unmanageable obligations and work toward rebuilding their financial stability. Efficient resolution. Chapter 7 bankruptcy is generally a quicker process compared to other types of bankruptcy, such as Chapter 13, which involves a repayment plan. The streamlined nature of Chapter 7 allows for a more efficient resolution of the debtor's financial situation. It is essential to remember that not all debts are dischargeable under Chapter 7, and there are certain criteria that individuals must meet to qualify. Additionally, Chapter 7 bankruptcy has long-term consequences on credit and financial standing.
Lesson 1B: Advantages of a Chapter 7 bankruptcy. Yes, there are several advantages to filing for Chapter 7 bankruptcy, especially for individuals and businesses facing overwhelming debt and financial difficulties. Some of the key advantages of Chapter 7 bankruptcy include debt discharge. The most significant advantage of Chapter 7 bankruptcy is the discharge of most unsecured debts. Once debts are discharged, the debtor is no longer legally obligated to repay them. This provides a fresh financial start and relieves the burden of unmanageable debt. Automatic stay. Filing for Chapter 7 triggers an automatic stay, which immediately stops creditors from pursuing collection actions. This means no more harassing phone calls, letters, wage garnishments, lawsuits, foreclosures, or repossessions during the bankruptcy process. Quick process. Compared to other bankruptcy chapters such as Chapter 13, which involves a repayment plan over several years, Chapter 7 bankruptcy is generally a quicker process. In many cases, it takes around 3 to 6 months to complete. No repayment plan. Chapter 7 does not require the debtor to propose a repayment plan to creditors. Instead, the bankruptcy trustee liquidates non-exempt assets to repay a portion of the debt. This makes the process more straightforward for debtors who don't have a stable income or cannot commit to a long-term repayment plan. Exemptions protect assets. Many assets are protected from liquidation through state-specific exemptions. Debtors can keep essential possessions, such as clothing, furniture, some equity in their home, tools of the trade, and a vehicle up to a certain value, depending on their state's laws. Relief from debt. For individuals or businesses overwhelmed by debt, Chapter 7. Bankruptcy can provide significant relief from financial stress and uncertainty. Credit improvement. While Chapter 7 bankruptcy does have a negative impact on credit initially, it also offers a chance to rebuild credit over time. With the burden of unmanageable debt lifted, debtors can work on improving their financial situation and credit worthiness.
Lesson 1C: Why you should not file a Chapter 7 bankruptcy. While Chapter 7 bankruptcy can be beneficial for individuals and businesses facing overwhelming debt, it is not the right solution for everyone. There are certain situations in which filing for Chapter 7 bankruptcy may not be the best course of action. Here are some reasons why someone might decide not to file for Chapter 7 bankruptcy. Non-dischargeable debts. Chapter 7 bankruptcy does not discharge certain types of debts, such as child support, alimony, most tax debts, student loans in most cases, and debts arising from fraud or intentional wrongdoing. If a significant portion of the debt falls into these categories, filing for Chapter 7 may not provide the debt relief the individual or business needs. Asset liquidation. In Chapter 7 bankruptcy, the bankruptcy trustee will liquidate non-exempt assets to repay creditors. If the debtor has substantial non-exempt assets they want to keep, they may choose not to file for Chapter 7 to protect those assets. Income above the means test. To qualify for Chapter 7 bankruptcy, individuals must pass the means test, which evaluates their income and expenses. If their income exceeds the state median, or they have enough disposable income to repay some debts, they may not be eligible for Chapter 7 and may need to consider alternative options like Chapter 13 bankruptcy. Long-term credit impact. Chapter 7. Bankruptcy has a severe impact on credit, and the record of bankruptcy can remain on the individual's credit report for up to 10 years. If the debtor anticipates needing credit in the near future or is concerned about future financial decisions, they might decide not to file for Chapter 7 to preserve their credit rating. Loss of non-exempt property. As mentioned earlier, some assets may not be protected by exemptions and could be subject to liquidation in Chapter 7 bankruptcy. If the debtor is not willing to part with these assets, They may consider alternatives such as debt negotiation or debt consolidation. Moral or ethical reasons. Some individuals may have strong moral or ethical objections to filing for bankruptcy and prefer to explore other options for debt relief, such as debt counseling, negotiating with creditors, or seeking alternative repayment plans. Impact on cosigners. If the debtor has cosigners on loans, filing for Chapter 7 bankruptcy could have adverse effects on the cosigner's credit and financial situation.
Lesson 1. D. Understanding the types of credit. In bankruptcy, there are two primary types of creditors: secured creditors and unsecured creditors. These creditors have different rights and priorities when it comes to the distribution of assets during the bankruptcy process. Here's an overview of each type. Secured creditors. Secured creditors hold a security interest or lien on specific property or assets of the debtor. This means that if the debtor defaults on the debt, the secured creditor has the right to repossess or foreclose on the collateral to satisfy the debt. Common examples of secured debts include mortgage loans. The lender holds a mortgage on the debtor's real estate, giving them the right to foreclose on the property if the debtor fails to make mortgage payments. Auto loans. The lender holds a security interest in the debtor's vehicle, allowing them to repossess the car if the debtor defaults on the loan. Secured personal loans. Some personal loans may be secured by specific assets, such as jewelry or other valuable items. In bankruptcy, the treatment of secured creditors varies based on the chapter of bankruptcy filed. In Chapter 7 bankruptcy, the debtor may choose to surrender the collateral and discharge the debt, or reaffirm the debt and continue making payments to keep the property. In Chapter 13 bankruptcy, the debtor can propose a repayment plan to catch up on missed payments and keep the collateral. Unsecured creditors. Unsecured creditors do not hold a security interest in any specific property or assets of the debtor. Therefore, if the debtor defaults on unsecured debts, the creditor cannot repossess any specific property. Common examples of unsecured debts include credit card debt, medical bills, personal loans without collateral, utility bills, certain tax debts, depending on the circumstances. In bankruptcy, unsecured creditors are typically paid last, after secured creditors and administrative expenses. Chapter 7. Bankruptcy usually discharges most unsecured debts, meaning the debtor is no longer obligated to repay them. In Chapter 13 bankruptcy, unsecured creditors may receive partial payment based on the debtor's disposable income and the terms of the repayment plan. It's essential for debtors to understand the types of creditors they have and the implications of bankruptcy on each type of debt.
Lesson 1. E. What credit is dischargeable? In Chapter 7 bankruptcy, most unsecured debts are dischargeable, meaning the debtor is no longer legally obligated to repay them. However, certain types of debts are generally not dischargeable under Chapter 7. It's essential to understand which debts can be discharged and which cannot. Here is a list of some common credit and debt types that are typically dischargeable in Chapter 7 bankruptcy. Credit card debt. Most credit card debts are dischargeable, including balances on various credit cards. Medical bills. Unpaid medical bills can generally be discharged in Chapter 7 bankruptcy. Personal loans. Unsecured personal loans, such as loans from family or friends, are usually dischargeable. Past due utility bills. Debts owed to utility companies such as electricity, water, or gas bills can be discharged. Payday loans. Debts from payday loans are typically dischargeable in Chapter 7 bankruptcy. Overdue rent and leases. Debts arising from unpaid rent and broken leases can be discharged, but the debtor may need to give up the property. Civil judgments, non-fraudulent. Unsecured civil judgments, such as from a lawsuit, are dischargeable if they are not related to fraud or intentional wrongdoing. Collection agency accounts. Debts that have been sold or transferred to a collection agency are generally dischargeable. Unsecured personal debts. Other types of unsecured personal debts, not specifically exempted by law, are dischargeable. It's important to note that while these types of debts are generally dischargeable, what credit is non-dischargeable? There are exceptions and specific circumstances in which some debts may not be eligible for discharge. Non-dischargeable debts in Chapter 7 bankruptcy include, but are not limited to, child support and alimony. Debts related to child support and alimony obligations cannot be discharged. Certain tax debts, income tax debts and other tax obligations may be dischargeable if they meet specific criteria, but some tax debts are non-dischargeable. Student loans. In most cases, student loans are not dischargeable in bankruptcy unless the debtor can demonstrate undue hardship, which is difficult to prove. Government fines and penalties. Fines and penalties owed to government agencies are generally not dischargeable. Debts resulting from fraud or misrepresentation. Debts incurred through fraud, misrepresentation, or other dishonest actions are not dischargeable. Certain court-ordered restitutions. Court-ordered restitution for criminal acts is usually not dischargeable.
Lesson 1F. Does your assets and income qualify for a Chapter 7 bankruptcy? Both assets and income are factors that can affect a debtor's eligibility for Chapter 7 bankruptcy. To qualify for Chapter 7 bankruptcy, debtors must meet specific criteria related to their income and assets. Here's how these factors come into play. Income and the means test. Chapter 7 bankruptcy involves a means test that assesses the debtor's income to determine if they are eligible for this chapter. The means test compares the debtor's average monthly income over the past 6 months to the median income in their state. If the debtor's income falls below the state median, they typically pass the means test and are eligible for Chapter 7. However, if the debtor's income is above the state median, they may still qualify if they can demonstrate insufficient disposable income to repay their debts after accounting for specific allowable expenses. If their disposable income is below a certain threshold, they can proceed with a Chapter 7 bankruptcy filing. Assets and exemptions. In Chapter 7 bankruptcy, a bankruptcy trustee is appointed to liquidate non-exempt assets and distribute the proceeds to creditors. However, most states have exemptions that allow debtors to protect certain assets from liquidation. These exemptions vary from state to state but generally cover essential items such as a certain amount of equity in a primary residence, personal belongings, retirement accounts, and tools of the trade. If the debtor's assets are predominantly non-exempt and have significant value, they might not qualify for Chapter 7 bankruptcy. In such cases, Chapter 13 bankruptcy, which involves a repayment plan, might be a more suitable option. Timing of bankruptcy filing. Timing is also crucial when considering Chapter 7 bankruptcy eligibility. If the debtor recently received a Chapter 7 bankruptcy discharge within the past 8 years, they might not be eligible for another Chapter 7 discharge.
Lesson 1F. Does your assets and income qualify for a Chapter 7 bankruptcy? Both assets and income are factors that can affect a debtor's eligibility for Chapter 7 bankruptcy. To qualify for Chapter 7 bankruptcy, debtors must meet specific criteria related to their income and assets. Here's how these factors come into play. Income and the means test. Chapter 7 bankruptcy involves a means test that assesses the debtor's income to determine if they are eligible for this chapter. The means test compares the debtor's average monthly income over the past 6 months to the median income in their state. If the debtor's income falls below the state median, they typically pass the means test and are eligible for Chapter 7. However, if the debtor's income is above the state median, they may still qualify if they can demonstrate insufficient disposable income to repay their debts after accounting for specific allowable expenses. If their disposable income is below a certain threshold, they can proceed with a Chapter 7 bankruptcy filing. Assets and exemptions. In Chapter 7 bankruptcy, a bankruptcy trustee is appointed to liquidate non-exempt assets and distribute the proceeds to creditors. However, most states have exemptions that allow debtors to protect certain assets from liquidation. These exemptions vary from state to state but generally cover essential items such as a certain amount of equity in a primary residence, personal belongings, retirement accounts, and tools of the trade. If the debtor's assets are predominantly non-exempt and have significant value, they might not qualify for Chapter 7 bankruptcy. In such cases, Chapter 13 bankruptcy, which involves a repayment plan, might be a more suitable option. Timing of bankruptcy filing. Timing is also crucial when considering Chapter 7 bankruptcy eligibility. If the debtor recently received a Chapter 7 bankruptcy discharge within the past 8 years, they might not be eligible for another Chapter 7 discharge.
(1H) means test part 2. Step-by-step explanation of the process. Gather income information. The debtor must calculate their current monthly income, which includes all sources of income received in the 6 months before the bankruptcy filing date. This includes wages, salary, bonuses, tips, rental income, self-employment income, unemployment benefits, pension, and any other sources of income. Compared to median income, the debtor's average monthly income is then compared to the median income for a household of the same size in their state. The U.S. Census Bureau and the U.S. Trustee Program provide the median income figures, which are regularly updated. If income is below median, if the debtor's income is lower than the median income for their state, they pass the means test, and they are generally eligible to file for Chapter 7 bankruptcy. If income is above median, if the debtor's income is higher than the median income for their state, they must proceed to the second part of the means test to determine whether they still qualify for Chapter 7 bankruptcy. Calculating disposable income. In the second part of the means test, certain allowed expenses are deducted from the debtor's current monthly income to calculate their disposable income. These expenses are based on IRS standards and may include items like housing, transportation, food, and healthcare costs. Assessing ability to repay. If the disposable income is substantial enough to repay a significant portion of the unsecured debts over time, the debtor may be required to file for Chapter 13 bankruptcy instead of Chapter 7. Chapter 13 bankruptcy involves a repayment plan that lasts 3 to 5 years, allowing the debtor to pay off a portion of their debts while retaining their assets.